Hello everyone. Today we are going to discuss the purpose of the act, the purpose of the Act of Payment Wages Act 1936. This we are going to cover under the law subject labor law. So under this law subject labor law, it is one of the important act which we are going to cover as per the syllabus. So let us have a look at the purpose of the act. The main objective of the act is to avoid unnecessary delay in the payment of wages and to prevent unauthorized deduction from the wages, right? Every person employed in any factory, upon any railway or through subcontractor in a railway, and a person employed in an industry or other establishment. The state government may by notification extend the provision to any class of persons employed in any establishment or class of establishment. The benefit of the Act prescribes for the regular and timely payment of wages on or before 7th day or 10th day of after wage period is greater than 1000 workers, and preventing unauthorized deductions being made from wages and arbitrary fines. So let us have a look at the salary statistics. Wages, let us have a look at this. Wages are averaging less than 6,500 per month only are covered or protected by the Act by the amendment in 2005 by section 1 clause 6. Wages means contractual wages and not overtime wages. They are not to be taken into account for deciding the applicability of the Act in the context of section 1 clause 6 of the Act. Wages must be paid in current coin or currency notes in both and not in kind. It is, however, permissible for an employer to pay wages by check off by crediting them in the bank account if so authorized in writing by an employed person. Let's move further. Summary of the provisions of the Act. The provisions of the Act regarding the imposition of fines on the employed person are as follows. As such, the employer must exhibit on his premises a list of acts or omissions for which fines can be imposed. Before imposing a fine on an employed person, he must be given an opportunity of showing cause against the fine. The amount of fine must not exceed 3% of the wages. A fine cannot be imposed on an employed person who is under the age of 15 years. A fine cannot be recovered by installments or after 90 days from the day of the act or omission for which it is imposed. The money realized from fines must be applied to purposes beneficial to the employed persons. Subsection 8 clause 3, 10 clause 1a and rule 15 deals with any person desiring to impose a fine on an employed person or to make a deduction for damage or loss shall explain personally or in writing to the said person the act or omission or damage or loss in respect of which the fine or deduction is proposed to be imposed, and the amount of fine or deduction which it is proposed to impose, and shall hear his explanation in the presence of at least one other person or obtain in writing. The procedure and competent authority which deals with the employment matters. Right? The procedure to employ a person has to follow for claiming deducted or delayed wages If contrary to the provisions of the Act, any deduction has been made from the wages of an employed person or any payment of wages has been delayed, he has to make an application for claiming the same to the authority appointed under the Act. Such application can be made by the employed person himself or a legal practitioner or an official of a registered trade union. Such application has to be made within a period of 12 months from the date on which from the date on which the deduction from the wages was made, or from the date on which the payment of wages was due to be made, right? There is a competent authority to entertain and decide an application for payment of subsistence allowance. The subsistence allowance payable to an employee placed under suspension pending departmental inquiry is covered within the definition of wages given under Section 2, Clause 6 of the Act, and therefore the authority is competent to entertain and decide an application for payment of subsistence allowance. The authority under the Payment of Wages Act is a court of summary jurisdiction, having powers to deal with the simple matter of delay in payment of wages or deduction from wages. It is not within the competence of authority to decide the question of the status of an employed person. The matter is a complicated question of law as also of fact. There is an agreement between an employer and his employees authorizing the deduction of union subscription from the salaries of employer, null and void under Section 23 of the Act. Such agreement being beneficial and advantageous to the employees is not null and void under Section 23 of the Act. So let us have a look at the employer's duty. The employer is required to display the abstract of the Act in his factory or establishment. Every employer must display in his factory or establishment a notice containing the abstracts of the Act and the rules made thereunder in English and also in the language understood by the majority or the persons. So the main crux of why this act has been enacted. So let us have a look at that. So this will help us to understand what is the purpose of this act, why it has been enacted, and how it helps an employee. So far whatever we have discussed, it gives us it gives us a picture about how this act is beneficial for the employee and how the employee can use it for its benefit, right? The Payment Wages Act is a regulation drawn up to protect the employee's right from being infringed by the employer, right? The employee should be paid on time and should not be harassed against anything during the employment. It has, however, given a lot of protection to employees and will continue to do so in the future as well, right? So it gives a right, it gives a tool in the hand of employees in case of any infringement of their rights. So with the help of the given measures given under the act, with the help of all those measures and provisions, an employee can fight for his right in case where he has not been paid wages properly, if the deductions which have been made that is not proper. So in case of any discrepancy, which in case of any injustice, in case of justice not being done with his salary, he can, with the help of the relevant provisions mentioned in the Payment Wages Act, with the help of all those provisions, an employee can fight for his proper wages, right, which he is entitled to, right? So with this we have come to the end of this topic. Thank you very much.